We regularly act for clients in the tech sector who develop and launch apps for consumers. They can be mobile apps, they can be web apps, and often it's both. Now, our clients usually get very, very excited about their apps when they're launching them. They focus on the marketing, they focus on getting as many customers on board, and in the course of doing so, they usually overlook the terms and conditions of the app. And it's important that these terms are not overlooked because the app terms need to comply with the Consumer Rights Act and associated legislation. This is important because consumers are considered a protected contractual counterparty in accordance with the legislation. As opposed to businesses, consumers are considered to have less commercial nous about them, and as a result, the legislation gives them more rights that need to be dealt with in the contract itself. So we'll talk about that in more detail later, but I'm going to pass over to Alex now, who's going to discuss enforcement and certain sanctions that might be coming your way if you don't produce acts that accord with the legislation.
So the number one issue is that unfair or blacklisted terms in consumer contracts are not enforceable because they create a significant imbalance in the relationship between consumers and traders to the detriment of the consumer. In the most serious cases, there can be criminal prosecutions where public safety isn't guaranteed. In less severe cases, you can face adverse consequences in the form of orders to pay compensation to consumers that have suffered a loss, guidance notices to prevent further breaches, and you can be ordered to publish details of your breaches online and in the press. In addition to that, consumers that think that your terms are unfair have got the right to bring a civil claim against you in court, which in the worst case scenario could result in a collective action for damages, bad press, and it's disruptive to the business, which isn't helpful at all.
I think we should take a step back at this point and consider whether or not a consumer contract is actually in play. What you need to do is almost look at your potential pool of customers and consider, are they going to be individuals who are primarily using your app for circumstances that fall outside of their usual trade, business or profession? If so, it's likely that a consumer contract is going to be in play. For example, when I first downloaded WhatsApp many years ago on my personal phone, I was clearly doing so for consumer purposes, and that's a consumer contract. By contrast, when I come into work here at Kingsley Napley and I log on to one of the cloud apps that we use for the various legal services we provide, Kingsley Napley's entered into that contract as a business, and that's not a consumer contract. We're now going to get into the nitty-gritty of the actual, legislation itself and what needs to be in those contracts. And I'll pass back to Alex to talk you through that.
So, save for a very limited number of exceptional cases, there are compulsory clauses that have to be included in online consumer terms of business. First and foremost, the right for the consumer to cancel in the cooling off period, which is at least 14 days from the date that they entered into the contract with your business. And in those circumstances, they have the right to cancel and receive a refund in full. In addition to that, it's essential that you include information about the contract length, termination rights, and any auto-renewal clauses that keep the contract running. Because in circumstances where a consumer feels that the contract is longer than they would normally expect, it's likely to be found as being an unfair contract. In respect to auto-renewal clauses, it's really important to make sure that those are fair. So, for example, reminding consumers a reasonable time before the renewal is due to take place, making changes to the terms such as pricing really clear so that they understand what the effect of the change will be after the renewal happens. Make it easy for them to cancel the contract, so you could include a link to a cancellation page, and don't impose any financial sanctions or penalties for them to terminate. Information about the length of the contract and these termination rights and auto-renewal should be made available on the order page so that they can see that information without navigating away just before they enter into the contract, so that they're going in with their eyes open.
I'm now going to discuss blacklisted clauses, i.e. clauses that should never be in your terms and conditions, as well as grey-listed clauses, certain clauses which are highly likely to be considered unfair and unenforceable if they are included in the contract. One term that you should consider not putting in there is something that tries to limit your liability to the consumer in the event that you breach the contract. You should avoid putting in terms that, for example, limit your liability and cap it to a level that's equal to whatever the consumer has paid to you under the contract. You should also avoid including terms which are excessively long in terms of the contract length. Take a step back, put yourself into the shoes of the consumer, look at your fixed term, and if it seems unreasonably long, simply reduce it. Something that shouldn't come as a surprise to you is that you shouldn't have penalty clauses that are excessive in your contracts with consumers. So, for example, as Alex was mentioning earlier, if you've got a cancellation provision in there, there shouldn't be an additional penalty that the consumer has to pay that's particularly excessive at the time of cancellation. Another thing that you should avoid is trying to keep all of the upfront fees that are paid for the service if the service is terminated early. In those circumstances where the consumer validly terminates the contract, anything that they've paid for that has not been provided yet should be reimbursed to them. And finally, you should always ensure that you don't have provisions in there that allow you to vary the contract unilaterally, i.e. without the consent of the consumer in any unfair way. For example, increasing the price of the contract without the consumer's consent or without giving the consumer a right to terminate the agreement. I'll now pass back to Alex, who can talk to you a little bit about the way the contract should be presented in order to make it enforceable.
So format and presentation are absolutely key for consumer contracts. In particular, they need to be transparent so that the terms are easy to understand. For that purpose, it's advisable to use plain English, short sentences, and avoid legal jargon that's likely to be unfamiliar and therefore deemed unfair because it's not clear what the contract is trying to say. In addition to that, they should be reader friendly. So, for example, you could use informative headings, subheadings, and a layered approach that makes the document easy to navigate by clicking on the heading to reach the relevant clause. And where there are clauses that will have significant implications for the reader, the consumer, such as limitation of liability, as Andy mentioned, where the circumstances in which a consumer can seek to recover compensation from you are limited in some way, or if there's warranties about the quality of the goods and services or their fitness for a particular purpose, then they should be drawn to the reader's attention either in capital letters or through bold text, and not hidden away in the body of the terms or discreetly included as small print. And to that point, it's essential that the terms and conditions are incorporated. So that means that the consumer has expressly acknowledged their acceptance of the terms. That's a key component of having an enforceable contract with consumers online. And now to Andy to conclude and sum up.
Hopefully we've made it clear that the key thing here is to ensure that your consumer contracts are clearly drafted, easily digestible, and most importantly, fair. If that's the case, you should be able to steer clear of bad press, disruptive litigation, and really importantly, you'll have a set of terms and conditions that are worth the paper that they're written on.